So welcome, Harry, welcome, Karina, and welcome, Rebecca, to tonight's session. It's now week 9. So we're about, welcome, Michael. Thanks for joining us again. So we only have 9, 10, 11, 12. We have 4 sessions to go. We're just about 3 weeks away from finishing the term, which actually ends on the first week of October. So congratulations for, hanging on in there. Because sometimes, with a lot of things going on in life, you feel like you don't want to finish it, you don't want to go on doing something, but patience does pay off. And so I'm glad that you've decided to persist in our unit. And so tonight, our topic is on Wednesbury Unreasonableness and the outer limits of legality. What we're again doing tonight, like in the past several weeks, is to examine the grounds for judicial review. And the reason why we're focusing mainly on the grounds for judicial review is that we need, unlike, for example, if you were undertaking merits review, it's a bit less complicated because assuming that the Adversative Appeals Tribunal has jurisdiction to undertake a review of an executive decision, the Adversative Appeals Tribunal therefore can examine the correctness of an executive decision both on the basis of the facts, it can also be on the basis of the law, and of course the exercise of discretion, as well as the exercise of decision-making on the basis of what public policy is. And so therefore, when you speak of merits review, you can even have a de novo hearing, and the Administrative Appeals Tribunal tries to examine everything about the case and tries to step into the shoes of the executive decision maker. But when it comes to judicial review of decisions, we need to be quite clear that judicial review is only available when there is an attack of an executive decision on the ground that there is some illegality or that the decision is contrary to law. So if you're talking about judicial review, you're looking at the validity of a decision from the viewpoint of whether or not the decision is contrary or according to the law. And so therefore, because you're looking at the lawfulness of decision, you want to know those instances when you can say that the decision is not lawful or the decision is contrary to law. And what we need to remember, therefore, is that the mere fact that an executive decision might be factually incorrect, and even if the error of a decision, the factual error of a decision is gross, it doesn't mean that that is a ground for, that alone is a ground for judicial review. So gross factual error is not a ground for judicial review, simply because a decision does not become contrary to law because, the appreciation by a decision maker of the facts is incorrect. For there to be, for example, a ground to invalidate an executive decision would have to mean, on the basis of issues about the facts, would have to mean that either there is no fact or evidence that supports the decision, or that taking into account the available evidence in a decision, the decision, for example, is just really illogical or unreasonable. And so therefore, what we're doing tonight, when we look at the idea of Wednesbury Unreasonableness, is that we're actually touching upon that issue about what you might say would be an attempt at looking at factual matters. As we said at the very start, judicial review is meant to examine either the process of decision-making itself or really examining whether the decision, not just the process of decision-making, but the content of a decision might be contrary to law. And so when we speak of factual incorrectness of a decision, that is usually not part of judicial review. So looking at the merits, the factual correctness of a decision is as a general rule, beyond the pale of judicial review. So you cannot, courts will not examine the, hello Tim, so courts in general will not examine, the evidence of a decision. It will not examine the merits of a decision. But there's actually an instance when courts somehow examine not just the process of decision-making, but actually examine the content of a decision. That's when the courts try to examine the reasoning in a decision, or the courts will try to examine the way that facts and evidence have been weighed by a decision maker in order for it to arrive at a decision. So, and this is when a decision might be said to meet the ground of Wednesbury unreasonableness, so that the decision is so unreasonable that no reasonable person or no reasonable authority could arrive at a decision. So the idea, therefore, oh, hello, Clinton. So Clinton is here as well. So how many do we have tonight? We've got about 1, 2, 3, 4, 5 students. Is it 6? Okay, very good. So I'm just going to mute everyone. So the point about Wednesbury unreasonableness is that this is one of those instances when it can be said that the court is almost examining the merits of a decision by looking into whether or not the decision is unreasonable. Because as we said, the idea about reasonableness is meant to be not within the confines of judicial review, mainly because when courts undertake judicial review is meant to be limited, and the courts only exercise a supervisory role over executive decision making. It doesn't act like an appellate body where it looks both at the law, the way the decision is made according to the law, as well as the facts. But because judicial review is limited to looking only at the lawfulness of a decision, it's not meant to examine factual matters or even the reasoning behind the executive decision. But when we speak of Wednesbury unreasonableness, this is one of those instances when actually courts try to examine the reasoning and the use of evidence in decision making, which is really quite close to examining the merits of a decision. So that's what we're going to be doing tonight. We will examine Wednesbury unreasonableness as a ground for judicial review. And we need to remember that as far as Wednesbury unreasonableness is concerned, when we look at the word, for example, Wednesbury unreasonableness, it does suggest to us from the word, Wednesbury, it does suggest to us that it is of common law origin. So when you look at Wednesbury unreasonableness, for example, we will realize that it comes from the common law, which eventually was codified in the Administrative Decisions Judicial Review Act of 1977 Commonwealth. But in the case, for example, in the UK in 1948, where the courts in the UK decided, in the case of Associated Provincial Picture Houses Limited versus Wednesbury Corporation, this was an instance where the courts asserted their authority to review decisions of the executive on the ground as to whether or not the decision made on the basis of the evidence and on the basis of the law might be said to be so unreasonable that no reasonable authority or person could arrive at that decision, because if it meets that standard of Wednesbury unreasonableness, then that decision has to be unlawful. It has to be contrary to law. So, for example, just as an example, before we go into detail on the topic, if there were an advertisement that was advertised, a job advertisement was put in the newspapers by a Commonwealth agency, and it gave the hiring committee the power to determine the requirements for hiring. And let's assume that they would disqualify people who have red hair, or disqualify people on the ground that they have black skin, or because they have a mole on the face, or they probably have a tattoo somewhere. You would probably argue that that kind of those kinds of rules would be very unreasonable. What do they have to do with whatever hiring is being done? So these are just as a simplified example. This is a simplified example of what might be said to be Wednesbury unreasonableness. So the ground of unreasonableness, therefore, started as a common law ground in the case of Associated Provincial Picture Houses Limited versus Wednesbury Corporation in the UK, and eventually it was adopted as part of the Administrative Judicial Decisions Review Act of 1977 Commonwealth, particularly Section 5 thereof. So what we're going to do tonight is to examine, therefore, this idea in greater detail. So tonight, after studying this topic, you should be able to discuss and explain unreasonableness, illogicality, and irrationality as grounds for judicial review, the requirements to establish unreasonableness as a ground of judicial review, and fraud and bad faith as grounds of judicial review. Now, what we always do before we have the discussion questions, we try to have a look at the quiz for the purpose of just trying to, highlight some factual issues there and probably, if need be, elucidate some relevant legal principles, particularly the one pertaining to tonight's topic. So can I just ask someone, one of you, to just read the quiz? So there are going to be two PowerPoint slides for the quiz. Can I just get somebody to read the question for us? I mean, the quiz question, and then so you need to unmute yourself. Can I get somebody to read?
Hello. Yeah. Hello.
Yes, Clinton. Thank you, Clinton.
Hello?
Yes, I hear you.
Yeah. All right. The Security Workers Act, Commonwealth Act, requires anyone seeking to practice as a security worker in a Commonwealth department, agency, or office to obtain a license from the Australian Department of Social Services and to meet certain requirements relating to education and training qualifications and physical and moral fitness. Sherlock Gordon applied for a security workers license with the ADSS in compliance with the Security Workers Act. His application was denied. However, because he was considered obese, Sherlock has come to you for legal advice about the DSS decision.
Okay.
And, which of the following statements is the most correct? Sherlock should be advised not to apply for a judicial review since the DSS decision was not unreasonable exercise of the statutory power that no reasonable person could have so exercised the power. B, Sherlock's right to natural justice has been breached. He should have been given an opportunity to be heard, such as presenting evidence of his physical fitness before his application was denied. C, Sherlock should be advised to apply for judicial review since the DSS decision was an unreasonable exercise of statutory power that no reasonable person could have so exercised the power. D, Sherlock should be advised to apply for a judicial review since the DSS decision was clearly unreasonable, unfair, and illogical. And E, Sherlock should be advised to apply for a judicial review since the question of whether he is physically fit or not is a legal question.
Thank you, Clinton. Would one of you or some of you care to make a comment as to the possible answers and try to say which one might be correct or why an answer might be wrong? I'm just going to convert this into letters, might make it easier. But before we do that, can I just ask you, again, no one's going to see this in the recording, can I just ask you to provide an answer in the chat box as to what you think is the correct answer? Now, what you need to remember is that in the actual quiz, the questions are shuffled. So, these kinds of answers, we will not be following the same order in the actual quiz in Moodle. But for our purpose, can you just try to provide an answer in the chat box as to what you think is the correct answer, and then we will take it from there. Again, this is just a practice. Just for me to get a gauge of, your level of understanding about the concept of Wednesbury Unreasonableness. Mm-hmm. Okay. Okay. Mm-hmm. Okay. So the answers, very good. So I can see that most of you actually got the correct answer. I'm not going to reveal what the answer is. Very good. So why did most of you arrive at this decision? I mean, at that answer? Because why did you arrive at that decision? I mean, at that answer? Can I get somebody to explain it? Yes, Michael, go ahead.
Hello?
Yes. Who was that? Let me go to Michael, and then somebody else was going to say something. Michael, I think I saw you raising your hand.
I would have thought that it would have been a reasonable decision on the part of the employer to deny his application, because appears on the face of it to have been strict requirements in the recruiting process, and the introduction indicated that he had complied with all of the processes of the recruitment. However, it was then found by the department that he was not employable because of his obesity. Therefore, I would have informed him on the basis of Wednesbury unreasonableness that then the decision was a reasonable one and not available for judicial review.
Very good. So the key point here, so you got the answers right. I think all of you did. You got the answers right, mainly because even though Wednesbury unreasonableness is a ground for judicial review, and as I said, it's in Section 5.2G of the ADJR Act of 1977 Commonwealth, actually the courts have said that it is not easy to find cases or instances when a decision actually meets the standards of Wednesbury unreasonableness. Because the only time you can say that there is Wednesbury unreasonableness is only when the decision is such that there is no reasonable person who could have arrived at that decision. Well, hang on, I'm just gonna unmute everyone again. Hang on. Okay. So in other words, if it is open, let's say you look at maybe 6, 7, 8, 10 possible executive decision makers, reasonable authority, reasonable persons, and they have scope to arrive at a disagreement as to what the decision should be. The fact that they could potentially disagree on what the decision should be means that there could be no Wednesbury unreasonableness. You can only say that there is Wednesbury unreasonableness when no reasonable person or no reasonable agency or reasonable authority could arrive at a decision. So if everyone therefore were to arrive at this decision, except for one person, then you might say that there would be Wednesbury unreasonableness. But if there is scope for this agreement, there can be Wednesbury unreasonableness. Okay, so the courts have said that it is difficult to see instances when a decision actually meets the standards of Wednesbury unreasonableness. Okay, so that's good. Questions so far before we move on to the discussion questions? So while it is a ground for judicial review, the courts have been very clear that it is really very difficult to meet the standards of Wednesbury unreasonableness, because the only time it can be said that a decision meets the standards of Wednesbury unreasonableness is only when there is no reasonable authority or reasonable person who could arrive at a decision. In other words, when you look at the facts, when you look at the evidence, you can say that there is only one correct decision. But when reasonable minds have an opportunity to reasonably agree, then you cannot have Wednesbury unreasonableness. Okay, questions before we go on? We're good. So let's examine the first discussion question. We have 5 discussion questions tonight. Can I again invite somebody to read discussion question 1 for us? Can I get a volunteer?
I can read for you.
Yes, Karina. Thank you, Karina.
Cornelius James, Senior Manager of Department of Social Services, DSS, was fired from his job after DSS investigate panel DSS IP found him to have committed sexual harassment against Jill Lockworth, his subordinate. The disciplinary proceeding against Mr. James had been based on the Public Sector Ethical Standard Act, Commonwealth, which prohibits sexual harassment. Mr. James asserts that the penalty of dismissal that was imposed is totally unreasonable and irrational, considering that he had been in government service for more than 20 years, always had the sterling performance reviews, and was at no time the subject of any disciplinary action or investigation. Given that he was so open to DSS-IP to impose a penalty such as a suspension apart from dismissal, it was totally unreasonable and irrational for it to have imposed a penalty of dismissal. Advise Mr. James on whether the decision met the Wednesbury Unreasonableness standard of judicial review.
Very good. Thank you, Karina. Can I just ask again, everyone, if you could, just on the chat box, indicate whether it meets the Wednesbury Unreasonable standard of judicial review or not. Okay. So yes, if it meets the Wednesbury Unreasonableness standards, and no, if it doesn't. Very good. This will be, I see an answer from Karina, from Rebecca, Tim, Clinton, and Michael. Very good. You got the answer right. So the answer is correct. No, it doesn't. Can I get somebody to try to explain why you think it doesn't meet the standard of Wednesbury Unreasonableness?
Hello?
Clinton, yes.
Yeah, well, in the Act, you're not allowed to, it prohibits sexual harassment, and he's been found to have committed sexual harassment. So it's unreasonable that he should have a job there, or he should not be like in trouble for it, you know?
Okay. So why do you suppose it doesn't meet the Wednesbury Unreasonable standard of judicial review?
I think there is no mention about whether he committed sexual harassment or not, and that's clearly prohibited by the Act. So the question is, there was other disciplinary action as an outcome of the investigation, such as suspension instead of dismissal. And given the good history of his service in the government, he says he shouldn't have been dismissed. So, what the reason I say that is that because he's not disputing that there was a sexual harassment sort of circumstances. So, but it is very, very difficult to say no reasonable person would not have arrived at the decision of dismissing Mr. James. So therefore, it's not enough to satisfy the Wednesbury reasonableness standard.
Very good. Very good. Can somebody else, try to provide an answer, an explanation as to why you think the decision is actually valid and it does not meet the Wednesbury Unreasonableness standard of judicial review? Anyone else? Michael?
Well, I would have said that it doesn't meet the standard of unreasonableness because the investigative panel had a number of decisions that it could arrive at having regard to the offence that had been committed. And because it chose a particular penalty doesn't make it so unreasonable that it could be overturned. I would probably go so far as asking to get an explanation as to the penalty, and if they completely disregarded his sterling performances, etc., then maybe there is an avenue open to him.
But going back, in relation to your point, Michael, that you're kind of saying that you're going to ask for reasons for the decision, and assert that, you know, he's got a sterling performance, so therefore he shouldn't be penalized with a dismissal. Do you suppose that he will in fact be successful if he were to apply for judicial review along those grounds? You know, if he were to make that kind of argument, he has, you know, he admits he committed sexual harassment. There is evidence. He admits that, but he's saying, you know, given his sterling performance, a penalty of dismissal is unreasonable. It shouldn't have been imposed. What, you know, how do you suppose will the courts look at that kind of argument?
Well, if the panel had only looked at the sexual harassment and completely disregarded his 20 years of service, his sterling performance reviews, and lack of any other disciplinary record, then have they acted illogically or irrationally or unreasonable? The answer to that then may be yes, and therefore there is an opportunity for him to apply for a judicial review.
Let's assume, Michael, that the DSS investigative panel, or the decision makers, ignored the sterling performance of Cornelius James. So they disregarded that. They said, you know, you've done a great job. You've never committed any mistake. You've never done any wrong before until today. But despite your sterling performance, despite your history of excellent performance, the fact is you've committed sexual harassment. And under the law, we have an option of either suspending you or dismissing you, and yet we choose dismissal. The question is, that decision, would that have met the standard of Wednesbury Unreasonableness? If they disregarded the sterling performance, they disregarded the history of an absence of any wrongdoing or infraction on the part of Cornelius James, would that meet the standard of Wednesbury Unreasonableness? Well,
I would say it would, because again, it comes back to the issue of fairness. Has he been fairly judged? Is it open for the court to state that the legal consequence or the decision was a legal error because they have failed under the relevant Ethical Standards Act, Public Sector Ethical Standards Act, to properly judge him?
Okay, Karina, it would have been nice. You know, Karina here gave a very fantastic explanation. It would have been nice if you make it public, Karina. It's a very good answer there. Now, Michael pointed out the issue about fairness. So he was saying it's unfair, therefore it's unreasonable. They're not the same. There is no requirement that, you know, if a decision seems to be unfair, therefore it is unreasonable. That's one. Secondly, you know, it's often, the courts have observed that it's quite common for people to say that when a decision is unreasonable, then, you know, they think that that is a ground for judicial review, but not every unreasonableness is in fact a ground for judicial review. What is required is Wednesbury unreasonableness, or unreasonableness that no reasonable person could have arrived at that decision. So in this particular case, if it can be said that it is open for the decision makers to, you know, consider imposing the penalty of dismissal because the infraction is sexual harassment, it cannot meet the standard of Wednesbury unreasonableness. And certainly, just because, you know, somebody has had a sterling performance in the past, simply because somebody has never committed an infraction before, is no excuse to say that you can commit sexual harassment. Okay, and it brings to mind that issue about Serena Williams in the tennis match. Have you seen that tennis video? That yes. She was saying, "Oh, I've never cheated before, and therefore, because I've never cheated before, it's okay for me to lash out at the umpire." Well, that's not the way it works. You know, it's like, I've never killed somebody before. I've only killed somebody today, only once. It doesn't make a difference. The fact is, you've committed a crime. So here, when we speak of Wednesbury unreasonableness, we have to remember Wednesbury unreasonableness is not the same as just unreasonable. So a decision can be unreasonable. We can agree it's unfair. We can agree, oh, there is no reason for it. It's illogical. But that is not sufficient. That is not sufficient as a ground for judicial review. It has to be Wednesbury unreasonableness, or a decision so unreasonable that no reasonable person could arrive at the decision. Okay, so let's move on. I'd like to compare that to this particular question. Kind of similar. Let's have a look at this. So we're just jumping to problem 5. Can I get somebody to read problem 5 for us?
I'll read it for you.
Yes, Karina, go ahead.
Alfred Monks, a clerk of Department of Social Services, DWS, was fired from his job after DWS investigate panel DWS IP found him to have stolen stationery in the amount of $20. The disciplinary proceeding against Mr. James had been based on the Public Sector Ethical Standard Act, Commonwealth, which prohibits theft. Mr. Monks asserts that the penalty of dismissal that was imposed is totally unreasonable and irrational, considering that he had been in government service for more than 20 years, always had the sterling performance reviews, and was at no time the subject of any disciplinary action or investigation. Given that it was open to DWS IP to impose a penalty such as reprimand or suspension, it was totally unreasonable and irrational for it to have imposed the penalty of dismissal. Advise Mr. Monks on whether the decision met the Wednesbury unreasonableness standard of judicial review.
Very good. Can I again ask the 6 of you to provide an answer in the chat box as to whether or not you think it meets the standard of Wednesbury unreasonableness? So no means it doesn't meet the standard. Yes, it meets the standard. So we've got answers here. No from Karina, no from Clinton. Can I get an answer from the others? No from Tim? No from Michael. Yes from Clinton. Yes, it meets the standard of Wednesbury unreasonableness from Clinton. Are we able to get an answer from Rebecca? Yes from Rebecca. So there are 2 versus 4. Okay. Let's try to make it even clearer. Let's look at the decision making even clearer. Let's assume that the amount of stationery stolen was only $1 instead of 20. And the decision was dismissal. It was open, of course. The law is clear. It's open to the DWSIP to suspend somebody, reprimand, or even impose the penalty of dismissal. Let's assume that it's open to the DWSIP to impose any of those penalties. And let's assume that the amount of stationery stolen was only $1, okay, instead of 20. And then the penalty was dismissal. Would that meet the standard of Wednesbury unreasonableness or not?
Stealing a stationery worth of $1 would be a little bit difficult to say whether it means unreasonableness or not, because because of the amount of $1, the motivation to steal $1 will be quite questionable.
Well, how different is it from $20 as opposed to $1,000, as opposed to $5,000?
But when the DWSIP decide to interpret the law very narrowly, because the Act does not specify how much, it doesn't give any range, whether it doesn't specify the amount, it just says theft. Stealing $1 is still a theft, and therefore it meets the definition of the theft, the word theft, for the purpose of this Act. So I think dismissing Mr. Monks for $1 theft will still be reasonable. For DSSIP to dismiss him.
Interesting.
But it's because it's $1.
Yeah.
It's really difficult to say. It's difficult to say he was motivated to steal $1 worth of stationery.
Okay.
Maybe it was a mistake. I don't know. It's just.
Okay. Clinton, what do you think?
Oh, I'm wanting to borrow a pen here. I think it's pretty harsh and a bit petty for the way it's handled.
Very good. I would tend to side with Clinton and Rebecca on this one. I would think that the decision would have met the Wednesbury Unreasonable standard of judicial review. If you look at the case of Edelston versus Wilcox, the courts have said that even when it is within the power of executive decision makers, and they have the discretion to impose whatever penalty that they have, the fact remains that the exercise of such power must not be capricious, oppressive, or arbitrary. I mean, imagine, which is why I gave the example of $1. Imagine dismissing somebody because that person stole something worth $1. Isn't that capricious? Isn't that oppressive? Isn't that arbitrary? So even when an executive decision maker, has the power to do certain things, that power has to be exercised reasonably. It cannot be capricious. It cannot be arbitrary. It cannot be oppressive. And that is the case of Edelston versus Wilcox. In this particular case, the theft of the amount of $20 and the penalty involved is dismissal. I think I would argue strongly that is just unreasonable. How could a reasonable person impose a penalty of dismissal for the theft of $20, given the fact that this guy, Monks, has been there for 20 years and has at no time been the subject of any disciplinary action or investigation? We're not talking of the theft of $5,000 worth of things. That's something else. We're talking of $20. We're not talking of him stealing confidential information. We're not talking of him committing sexual harassment. We're talking of theft of $20. And I think, following the case of Edelston versus Wilcox, I think a lot of reasonable persons are likely to agree that it is unreasonable, it is capricious, arbitrary, and oppressive to terminate the employment of somebody for stealing $20 worth of stationery. Okay? Let's go back to problem 2 now. Can I get somebody to read problem 2 for us? So the point there, to the question of Tim, an instance when an executive power is exercised very arbitrarily, very capriciously, and oppressive, that can be a ground to say that the decision meets the standard of Wednesbury unreasonableness. It is not the fact alone, Tim, that it is arbitrary. A decision can be arbitrary, a decision can be unreasonable, a decision can even be capricious. But when a decision is so arbitrary, capricious, or unreasonable that no person could arrive at that decision, that's when it meets the standard of Wednesbury unreasonableness. So it is two things. It is unreasonable, arbitrary, or oppressive, or capricious. And because of its being arbitrary, capricious, or oppressive, or unreasonable, no reasonable person could arrive at that decision. So it's those two things. Arbitrariness on its own, unreasonableness on its own, oppressiveness on its own are not sufficient grounds for judicial review. But when you couple it with that other argument or assertion that no reasonable person could have arrived at that decision, then it can be said that that meets the standard of Wednesbury unreasonableness, or a decision that is so unreasonable that no reasonable person could arrive at the decision, as stated in Section 5.2g of the Administrative Decisions Judicial Review Act of 1997 Common Law. Okay. Problem 2. Can I get somebody to read problem 2 for us?
Yeah, I'll read it.
Thank you, Tim.
After finishing a diploma of community services work at the Goodness Wood Technical Institute, Sherlock Gordon applied for a social support worker's licence with the Australian Department of Social Services, the DSS. The Social Support Workers Act, Commonwealth, requires anyone seeking to practice as a social support worker to obtain a licence from the DSS and to meet requirements as to moral fitness. Gordon submitted all of the requirements, including a police clearance, that stated that he has no record of any criminal conviction. The DSS, however, received an anonymous call saying that Gordon had been the subject of a police investigation for child molestation in 2005. That investigation had even been covered in the news at that time. Because of the unwillingness of any witness to come forward, the investigation had subsequently been terminated. Gordon was later informed by the DSS that it had concerns about his moral fitness because of the complaint against him for child molestation in 2005, and hence could not issue him with a social support worker's licence. He has come to you as a solicitor for advice. Advise Gordon on whether he can apply for judicial review on the ground that the DSS decision was unreasonable.
Very good. Thank you, Tim. Can I again ask everyone to try to provide an answer? Yes, if you think that the decision meets the standard of Wednesbury Unreasonableness, and no, if you think it doesn't meet the standard of Wednesbury Unreasonableness. So as we can see here, there is no record of criminal conviction, but there is an anonymous call, and that it was subject of a police investigation covered in the news at that time. But there are no witnesses. Unwillingness of witnesses. Okay. Yes, no, what do you think? So yes, if you think it meets the standard of Wednesbury Unreasonableness, and no, if you think it doesn't. So the class seems divided. Can I ask someone to, provide an answer? It's half-half. Well, 3 yes, 2 no.
Hello. Yeah.
Yes, Clinton?
I think a merit review are allowed to have hearsay evidence taken into account.
Okay.
The merits review.
Yep. Remember, we're talking here of judicial review. We're not talking of merit review here. So we're just really looking at the ground. We're just looking at Wednesbury Unreasonableness as a ground for judicial review. We're looking at the courts undertaking a review of an executive decision. So this isn't about the Administrative Appeals Tribunal. What do you think?
I think a person is presumed innocent until proven guilty. Mm-hmm. And the fact that he was subject to a criminal investigation doesn't or shouldn't prevent him from future work.
Okay. What do you suppose is the threshold question that really should be asked when you talk about Wednesbury Unreasonableness? What is that question that you should be asking yourself for you to know that it meets the standard of Wednesbury Unreasonableness? What is that question?
Illogicality and irrationality, and this decision is, it could be said it is an irrational decision because it was an anonymous call who doesn't want to be identified, and also even relying on the media report such as news and I don't know where the unwillingness of any witness come forward is actually coming from, but there is no supporting evidence of it's merely an assertion at this stage, and the assertions need to be supported by the evidence, and there is no evidence to actually rationalize the suspicion. And the decision maker should have sought to rationalize the suspicion or to address the suspicion before he or she made a decision. So I will say the decision was irrational and illogical. So therefore qualify for the Wednesbury reasonableness test.
Okay. Can I just make a comment? Thank you, Karina. That was a good argument you made there. What we need to point out is that when we say that the decision is illogical, we're simply saying that the decision lacks logic, or maybe it's weak in logic. When we say that the decision is irrational, we're often saying that the decision is not grounded in reason. Okay, But the mere fact alone that a decision may be illogical, meaning you can say that the logic there is poor, or that there is no logic in it. Or when you say that there is no reason behind it, or that the reasoning is poor, that alone will not invalidate an executive decision. That has to be very clear. Okay? So the mere fact that a decision appears to be illogical, appears to be unreasonable, will not invalidate a decision on the ground of Wednesbury Unreasonableness. So I go back to my question. What is the threshold question you should be asking about Wednesbury Unreasonableness? Okay, let me provide the answer. Would somebody like attempt an answer? Lack of plausible justification. Okay, yeah, but is that enough? What's the threshold question there? What's the question you should be asking? Michael? Yeah, okay, go ahead, yeah.
Was the decision of the department so unreasonable that no reasonable person could have come to that decision?
That is the question you always ask. It's not just a question of whether the decision is unreasonable or illogical. The question, as clearly pointed out by Michael, you should be asking when it comes to Wednesbury Unreasonableness is really whether there is no, that the decision is so unreasonable. One, so it's so unreasonable that no reasonable person could have arrived at that decision. Those two things must be there. Here, okay? And let's talk about what Karina said about evidence, okay? Let's go back to the issue about evidence. Is there a requirement? So, because remember, we're trying to connect here the notions of natural justice, for example, okay? We said that when the rights of a person are infringed, the rights, interests, or legitimate expectations are potentially infringed by an executive decision, then that person must be given the right to natural justice, okay? And in fact, when you speak of right to natural justice, that's often translated as the duty of decision makers to act judicially. And when we say that decision makers must act judicially, like judges, we often associate judges acting on the basis of evidence, right? They don't make decisions without evidence. Now the question is, if we say that there's a duty on the part of decision makers to act judicially or act and observe the right to natural justice, when their decision can infringe the rights, legitimate expectations, or interests of a person, would it mean that executive decision makers must follow the same rules of evidence required in courts? So in other words, anonymous call, that won't, the courts won't accept anonymous calls. And, subject of a police investigation, that's really difficult. That's really unproven. News, that's just an allegation. But the question is, are executive decision makers required to have the same standard of evidence as courts when executive decision makers are required to act judicially? Is that the case? Or even the AAT, the Adversative Appeals Tribunal, when it undertakes merits review, is the Adversative Appeals Tribunal required to follow the strict rules of evidence followed by courts? Or can they actually accept hearsay evidence? And I saw Michael shaking his head. What do you think, Michael?
Oh, sorry, they're not required to accept evidence. They can take hearsay if they see fit. So there's no requirement on them to accept only evidence that is judicially acceptable.
Okay, so let me just clarify, Michael, in terms of the way you provided the answer. Can an executive decision maker base a decision on hearsay evidence? That's my question.
Oh, he can accept hearsay evidence if he so wishes.
Very good.
He's not bound by the rules of evidence.
Exactly. That's correct, Michael. So Michael is correct. As far as executive decision makers are concerned, even if they are required to act judicially because they have to observe the rules of natural justice. They are not required to observe the same rules of evidence as courts. So even the AAT relaxes the rules of evidence, and so therefore it would accept hearsay evidence. And we will see therefore a connection, I think, when we look at the topic next week, which is about rules of evidence. We will see a distinction between a decision by the executive where there is no evidence as opposed to evidence being weak. And we will see that the mere fact that evidence is weak or evidence is very poor doesn't nullify the decision. The only time when a decision can be invalidated is when there is really no evidence, because an absence of evidence means that the decision is invalid. It is unlawful, because every decision has to be based on evidence. But if there is evidence, even if evidence is one that wouldn't have been accepted in a court of law, that is still evidence that is accepted. Okay, so what is the correct answer here? So the correct answer here would be that, if you look at the facts, there is evidence. There is an anonymous call. We know that there has been a police investigation pertaining to child molestation. We even know that it was covered in the news at the time. Well, we certainly, Sherlock Gordon hasn't been convicted in a court of law. But the mere absence of conviction doesn't mean that he did not commit, or that he was, blameless for committing, what was the allegation? Child molestation, right? It's like somebody saying, oh, but I haven't been convicted, therefore I didn't do it. Those are two different things. There is a requirement that somebody has to be convicted of a crime before you can assert that the person has committed something. Would you agree?
No.
Tim, go ahead.
The anonymous caller has simply said that he was subject to a police investigation.
Very good. For child molestation.
They haven't given any evidence that he actually did it.
Yes.
So I think it would be pretty unreasonable to make the stretch to say that, well, he must have done it because he was on television.
Okay, very good. I like that argument, Tim. It's a very strong argument. The question I'd like to ask is, put yourself in the shoes of the Department of Social Services. And of course, they want to take care of kids, right? They don't want to hire somebody who has a potential record of child molestation. And so they want to keep it safe. So they know they've received an anonymous call that somebody has been the subject of a police investigation for child molestation. It was even covered in the news. The question then is, would it be unreasonable? Would it be a decision such that no reasonable person could have arrived at that decision? Can it be said that, out of maybe 20 reasonable persons, reasonable authority figures, not one of them can say that perhaps there is a basis for the claim or allegation that Sherlock Gordon has committed child molestation? Or is it actually open on the evidence that's there for a reasonable person to conclude that Gordon may have engaged in child molestation? Is it open to a reasonable person to arrive at a decision that Gordon may have committed child molestation? That's the question I have. Is it open? Because if the answer is it is open for a reasonable person to believe that child molestation could have been committed by Sherlock Gordon, then it does not meet the standard of Wednesbury Unreasonableness. Because you can only have Wednesbury Unreasonableness when, for example, when the evidence is such that there can only be one possible conclusion on the basis of evidence. But if reasonable minds among reasonable persons can disagree as to what the conclusion would be, then you cannot have Wednesbury Unreasonableness. Okay, that to me would be the better argument. I do agree that you've got a strong point there. Yes, Tim.
I don't think a reasonable person could come to a conclusion that he shouldn't get the license because somebody said he's been subject to a police investigation.
Yes, Michael.
Let me put it this way then. Police will only investigate a matter if there's a complaint. And usually with child molestation, the complaint comes from a child.
Uh-huh.
And it would appear as though because the police haven't been able to prove the child's been molested beyond a reasonable doubt,
Very good.
which is their onus,
Yeah.
they can't proceed.
Correct.
Does that mean then that the child or the complainant
Very good.
has not been molested?
Uh-huh.
That would be the moral concern that I would have regarding his fitness if I was the employee looking at his file.
That is the kind of...
There goes the unreasonableness nature. Would a judge sitting there say that that decision made by the employer was so unreasonable, having regard to the fact that there has been a police investigation of this man for child molestation?
That's right.
That's what I would...
That is the kind of argument I'd like to hear, because as correctly pointed out by Michael, it may be that the police did not decide to investigate or even drop the charges because they felt there was, it couldn't be proven that there was a criminal offense, because you need a standard of evidence being beyond reasonable doubt. But if it were a civil case, if it were an administrative matter, the amount of evidence, the quantum of evidence required is obviously different. You're talking of balance of probabilities versus proof beyond reasonable doubt. Okay, so I mean, these are the kind of arguments I'd like to see. Yes, Karina.
Could I was just wondering, could I just also say the decision was made for the purpose of Social Support Workers Act.
Okay.
And the primary purpose for that act is to protect the vulnerable people as a social support worker.
That's right.
And that primary purpose and the obligation actually outweighs its responsibility to uphold the natural justice of the applicant.
That's right.
Is it reasonable to say that?
Yes, I agree with you. Yeah. I mean, in between, put yourself in the situation. Are you in fact going to hire somebody who has that tinge of doubt that he might have committed child molestation? You can't, right?
Yes.
I mean, you play it safe. So yeah, I mean, I'm willing, if this were a test, I'm willing to examine, arguments. That's the whole point about application of the rules of the facts. You need to see the argumentation there. But it would be very difficult to convince me, if somebody said that there's really no evidence and that, everyone will agree that not to have accepted him really meets the standard of Wednesbury Unreasonableness. Okay, it's 6:58. Maybe we could move on. Now, I like the discussion there. Very good. Okay. Can I get somebody to read problem 3 for us?
I'll read it for you.
Hello?
Yes.
I'm
Clinton? Yes. Clinton?
All right. Yeah.
You want to read it? Go ahead, Clinton, please. Go ahead.
The Security Workers Act, that Commonwealth requires anyone seeking to practice a security Commonwealth department, agency or office to obtain a licence from the Australian Department of Social Services and to meet certain requirements relating to education, training qualifications, physical and moral fitness and police and security clearances. Mitchell Smith applied for a security workers licence with the ADSS in compliance with the Security Workers Act. Upon review of his application, the ADSS came upon information that Smith had at one time been the subject of criminal investigation for child molestation in the UK while he was there to study for a university degree. The ADSS subsequently sent Smith a letter to inform him that unless he submitted evidence within 45 days or until the 3rd of August 2017 to show that he had been cleared in the criminal investigation and the reasons for such clearance, it would be inclined to reject his application. 5 days before the deadline given to the ADSS, Smith sent it a letter asking for an extension of 30 days, within which to submit the documents required by the ADSS. On the 10th of August 2017, the ADSS sent Smith a letter rejecting his application on the ground that he failed to meet the requirement about police and security clearances. He has come to you as a solicitor for advice. What advice would you give him?
Thank you, Clinton. Very good. So we notice here that what Smith had done was actually to request for an extension 5 days before the deadline, but the ADSS refused the extension. So because the ADSS refused the extension, Mitchell Smith therefore failed to provide evidence that would have countered or contradicted the allegations against him. Do you suppose that this meets the standard of Wednesbury Unreasonableness or not? Can I just get, again, for you to say yes or no?
But where do I see that the ADSS refused extension?
Ah, very good. Is it there?
No, it's not here.
Oh, it's not there. Okay. Okay. Let's just assume. So I may have, very good, Karina. I may have, I may have stated it there. So part of the facts, it's a good thing you noticed that. Part of the facts really said was that the ADSS refused to give him an extension. So I should add that. Okay. Okay, very good. Thank you, Karina. Okay. So there are some who said no, some say yes. Okay. The more correct answer is actually yes. Can I just get Michael to explain why you think? Because I'm going directly to Michael because I realize it's now 7 o'clock and some of you may go hungry. Yes, Michael. Why do you think?
Well, again, I went back to the case you talked about earlier, which was Edelston v. Wilcox, where they talked about capricious or oppressive exercise of a power. And to deny him the opportunity of an extension to provide proof that the investigation cleared him would be an excessive or oppressive exercise of the power. So
That's
therefore,
correct.
I would find that he would have an opportunity for judicial review.
That's correct. So if you look at the case of Said versus Minister for Immigration and Citizenship, as well as the case of Keogh versus West, which we discussed in the topic on natural justice, the courts have said that, in the ordinary case, when somebody's rights or interests or legitimate expectations can be adversely affected by a decision based on information that might be, adverse to that person should be given an opportunity to provide, an opportunity to be heard. He should be given, in the ordinary course of things, that person should be given an opportunity to provide information to counter an allegation against him. And so therefore, to deny that person an opportunity to counter evidence against him would be, number one, a denial of his right to natural justice, but more importantly, for a power to be exercised denying that opportunity to be a person would meet a standard of Wednesbury Unreasonableness. He was just asking for an extension of 30 days. There is no reason why a decision had to be quickly made. There was no reason why the extension couldn't be granted. So this I would think, would be an instance following the cases of Said versus Minister of Immigration and Citizenship, as well as Keogh versus West. This would be an instance where the exercise of the power by the ADSS would be oppressive and would meet the Wednesbury standard of unreasonableness. Okay, it's 7:05. This might be a good time for us to end, unless you have some questions, comments before we end tonight's session.
I've just got a question about the assignments.
Yes, Clinton.
When do we get a mark at all?
So the results of the midterm assessment will be released on Wednesday next week, as stated in the unit profile. So it takes about 2 weeks. And the reason for that as well is that we actually have about 10 students who still have yet to submit their assessments because they requested for an extension and they have valid reasons for the extension. So you're given a turnaround time of 2 weeks usually to return the assessment. So the assessment results will be released on Wednesday of next week at nighttime.
Thank you. And is it possible if you could release like the perfect answer so we can see what the perfect answer
I will. When I release the marks on Wednesday next week, I will provide an exemplar answer or exemplar answers. You will get that, but not before, because if I do, you'll have classmates who would know what the answers will be, because a lot of them still have to submit the answers. But I'm marking, I'm almost done with the marking actually, except for those who haven't submitted their papers. But when I release the marks on Wednesday of next week, I will provide an exemplar as to what the proper answers should be.
Having viewed some of the assessments, then are you happy with the results so far?
Yeah, I am. I'm very happy with the results. Okay, so with that, again, thank you for joining tonight's session. Clinton, Harry, Michael, Karina, Rebecca, and Tim. I like the discussion, and we've only got 3 more weeks to go. Wow, and you're going to be finished with administrative law. Well done. So thanks for joining tonight's session, and I hope to see you again next week. Good night.
Good night.
Thank you. Bye.